Imagine this for a second. The very systems meant to keep you safe, police, prosecutors, they fail. And because they fail, you suffer terrible harm. It's a really disturbing thought.
It is. And unfortunately, it's not just hypothetical.
Exactly. Today we're doing a deep dive into a huge South African legal case. Carmichele v. Minister of Safety and Security. In this case, well, it's more than just legal arguments. It's about one woman's fight after a horrific event. A fight that genuinely changed how we think about the state's duty to protect people.
It really did. It forced a hard look at responsibility.
So our mission today is to unpack this case. We'll look at the tragic story behind it, the legal twists and turns, and crucially, the massive constitutional impact it had. Okay, let's unpack this. It all starts with a terrible attack. On August 6, 1995, Alix Jean Carmichele was brutally assaulted by a man named Francois Coetzee in Notsi near Knysna.
Coetzee was eventually convicted, wasn't he? Attempted murder, housebreaking, got a sentence of 12.5 years.
He did.
Yeah.
But the truly shocking part, the reason this became a landmark case, isn't just the attack itself. It's the backstory. It's about Coetzee's history and the string of warnings that were, well, seemingly ignored by officials.
Right, and understanding Coetzee's background is absolutely vital here. This wasn't out of the blue. He had documented sexual problems going back to when he was just 10 years old, included molesting his own niece. His mother was concerned enough to seek medical help even then.
Wow, from age 10.
Yeah, and it escalated. In June 1994, when he was 20, he broke into a woman's house, an acquaintance, and fondled her while she slept. He actually pleaded guilty to housebreaking and indecent assault.
Okay, so a conviction. What happened then?
He received a conditionally suspended sentence, so no jail time, essentially a warning, which, in hindsight, well,
It seems like a massive red flag missed already.
a huge one. Because less than 6 months later, March 1995, he attacked again. This time it was a 17-year-old school friend, identified as E.T., and it was incredibly brutal, attempted rape, attempted murder. He punched, kicked, throttled, bit her, left her for dead.
Horrifying. So this escalating pattern was becoming undeniable.
Undeniable, this showed extreme dangerousness.
And this is where the state officials come directly into the picture, isn't it? After that attack on E.T., Coetzee actually turned himself in.
He did. He was arrested. And importantly, E.T. and her mother spoke to the police right away, to a Sergeant Janchis. They told her about Coetzee's previous conviction. They called it rape, which was their understanding of the indecent assault conviction.
Okay, so the police were explicitly told about his prior record involving sexual violence.
Yes, and it was noted down for the investigating officer, Detective Sergeant Klein.
So Klein gets this information, knows about the incredibly violent attack on E.T., knows about the prior conviction, and what does he do?
He interviewed E.T., interviewed Coetzee, and then recommended to the prosecutor, a Mr. Olivier, that Coetzee be released on warning. No bail needed.
Released after an attempted murder and with a prior sex offense conviction.
That was the recommendation. And then Prosecutor Olivier took it a step further. He didn't tell the Magistrate von Bratt, about Coetzee's previous conviction. And he didn't oppose Coetzee's release.
So the magistrate didn't even have all the facts.
Apparently not the key fact of the prior conviction. So
No.
just 2 days after that brutal attack on E.T., March 6th, 1995, Coetzee walked free, unconditionally released.
Unbelievable.
Oh.
How did people react, people who knew him?
Understandably, with alarm, especially Julie Gosling, who was a friend of Mrs. Carmichele. Coetzee's mother actually worked for Gosling. She was deeply worried he'd offend again.
So she tried to warn someone.
She did. She spoke directly to a police captain, Lawrence Oliver, and then to the senior prosecutor, Diane Liu. She told Liu she was scared Coetzee would hurt her or her friends.
And what did Prosecutor Liu say?
This is chilling. Liu apparently told Gosling that, essentially, their hands were tied, that there was no law to protect them, and authorities were, quote, powerless unless Coetzee actually committed another crime.
Powerless. That sounds inadequate.
To say the least. It was a direct warning, expressing clear fear, met with inaction. And Coetzee even went to E.T.'s house after being released, which terrified her mother, who called the police again, frantic that he was out.
And the inaction continued, even after more worrying signs.
It did. Just days after that first release, Coetzee attempted suicide. A relative, who happened to be a police detective, took him to Prosecutor Liu again.
Okay, so Liu sees him again. What happens this time?
In that meeting, Coetzee actually admitted to Liu he had problems controlling his sexual impulses. He even said a superhuman, unnatural force would overcome him. Very disturbing stuff.
You'd think that would trigger some serious alarm bells.
Liu did arrange for him to be sent to Valkenburg Hospital for 30 days of psychiatric observation. And she did note his history, the ET attack, the previous conviction, for the hospital.
So observation happened. What was the outcome?
He returned on April 18th, 1995. The assessment was that he was mentally capable, meaning fit to stand trial, not necessarily that he wasn't dangerous.
Right. So he comes back from psychiatric observation. What does the prosecution do now? Surely they argued to keep him in custody.
You'd think so. But prosecutor Olivier, the same one from the first release, again did not apply for Coetzee to be detained. He was released again on his own recognizance. Just let go.
This is staggering. Multiple warnings, admissions, a prior conviction, a brutal attack, psychiatric observation. And he's still released.
It's a pattern of missed opportunities or failures to act that is central to the case.
And the warnings still weren't over, were they? Ms. Carmichele herself encountered him.
That's right. In June 1995, she saw Coetzee acting suspiciously, snooping around Julie Gosling's house, where Mrs. Carmichele often stayed.
So, another direct report.
Yes. Gosling reported this to Captain Oliver again, who yet again referred her back to Prosecutor Liu.
And Liu.
Same response. According to Gosling, Liu reiterated she was powerless.
It gets even more direct, doesn't it? Just before the attack.
It does. On August 2nd, 1995, only 4 days before she was attacked, Mrs. Carmichele and Mrs. Gosling went together to confront Prosecutor Liu at Gosling's place of business. A face-to-face plea.
And Liu still maintained she could do nothing.
That was the testimony. She claimed again there was nothing she could do about Coetzee. 4 days later, he attacked Mrs. Carmichele.
So you paint a picture of, well, a dangerous person, known history, escalating violence, repeated direct warnings from citizens fearing for their safety.
And consistent inaction or claims of powerlessness from police and prosecutors.
Right. And that chain of events, that sequence of failures, is what led Alix Jean Carmichele to sue the government, specifically the ministers of safety and security and justice. Her argument was simple, but profound. Their officials failed her, and that failure led directly to the harm she suffered.
Exactly. And the legal question became, does the state owe a duty to protect people from harm caused by others, especially when its own officials know about the danger?
So how did that play out in court? What was the specific legal claim?
Her claim was based on something called delict in South African law. You can think of it as similar to tort law, a civil wrong causing harm.
Okay.
To win, she had to prove 3 main things. First, that the police and the prosecutors actually owed her a legal duty to act reasonably to prevent the harm. Second, that they breached that duty through negligence, carelessness, essentially. And third, that this negligent breach caused the attack and her injuries.
Duty, breach, causation, standard stuff in negligence cases, right.
Yeah.
But applying it to state inaction, that seems tricky.
Very tricky, especially under the common law at the time. And initially, it didn't go well for Ms. Carmichele. Both the High Court and then the Supreme Court of Appeal, the SCA, hit her with something called absolution from the instance.
Absolution from instance. What does that mean in plain English?
It basically means the court says, you haven't even presented enough evidence for us to potentially find in your favor. So the case gets dismissed without the defendants, the state, in this case even needing to present their defense.
Wow. So they shut her down early. Said she couldn't even possibly prove a legal duty existed.
That's essentially it. They found she hadn't made out a prima facie case, hadn't crossed the initial hurdle to show there might be a legal duty on the part of the police and prosecutors in these circumstances. For her, it looked like the end of the road legally.
But it wasn't. She went higher, didn't she, to the Constitutional Court?
She did, and her legal team brought a really crucial, constitutionally based argument.
What was the core of that argument?
They argued the lower courts made a fundamental mistake. They failed to properly consider Section 39 of the South African Constitution.
Section 39(2). What does that section do?
It's incredibly important. It says that when any court interprets legislation or when it develops the common law or customary law, it must promote the spirit, purport, and objects of the Bill of Rights.
Okay, so it's an instruction to courts. Make sure the law aligns with the Constitution's values.
Exactly. It's not optional. And Carmichele's argument was that the existing common law on state liability for omissions for not acting needed to be developed. It needed to be brought into line with the rights in the Bill of Rights.
Which rights specifically?
Things like the right to life, the right to equality, particularly relevant given the gendered nature of Coetzee's violence, the right to human dignity, freedom and security of the person, privacy, all these fundamental rights. The argument was, these rights don't just mean the state can't violate them directly. They might also impose a positive duty on the state to protect people from having their rights violated by others, like Coetzee.
So shifting from a purely negative, don't interfere view of rights to a positive must protect view.
Precisely. Especially concerning violent crime and the state's role in preventing it. They argued the lower courts just looked at the old common law and didn't do their constitutional job of seeing if it needed updating.
And how did the Constitutional Court respond to that argument about developing the common law?
They embraced it wholeheartedly. The court made it crystal clear that the Constitution is supreme. Section 39(2) isn't just a guideline. It imposes a direct obligation on all courts to ensure the common law is infused with constitutional values. If the common law deviates from the spirit of the Bill of Rights, courts have a duty to develop it.
So it's an active judicial responsibility.
Absolutely. They can't just wait for Parliament to change the law. They have to shape the common law themselves to align with the Constitution. And this applies even if the lawyers in the case don't explicitly ask for it. It's inherent in judging under the Constitution.
That's a powerful statement about the role of courts.
Yeah.
How did they compare this South African approach to other countries?
Well, they looked around. They noted the U.S. position, particularly under the Due Process Clause. Generally, U.S. courts distinguish sharply between state action that causes harm and state inaction or failure to protect from private harm.
Like in that Deshani case.
Exactly. Deshani v. Winnebago County. The U.S. Supreme Court basically said the Constitution doesn't generally impose a duty on the state to protect people from private violence. There's no constitutional liability for failing to prevent it in most circumstances.
But South Africa went a different way.
Yes. The Constitutional Court found the South African Constitution points strongly towards positive obligations. They also looked at the European Convention on Human Rights, citing cases like Osman v. United Kingdom. The European Court has recognized that states do have a positive obligation under the right to life, for instance, to take reasonable preventive measures if authorities know or ought to know of a real and immediate risk to someone's life from the criminal acts of another.
So the European approach was more aligned with where Carmichele wanted the law to go.
It suggested a similar direction, yes. The Constitutional Court explicitly said South Africa's constitution, with its emphasis on substantive equality, dignity, and security, strongly supports the idea that the state does have positive duties to protect fundamental rights.
What about the argument that holding police or prosecutors liable would open the floodgates to lawsuits or make them too timid to do their jobs? That old immunity idea.
Ah, yes, the public interest immunity argument. This came largely from English law, like the Hill case involving the Yorkshire Ripper investigation. The idea was that police shouldn't be sued for operational negligence because it would divert resources and hinder crime fighting.
Did the Constitutional Court buy that?
Not at all. They decisively rejected the idea of a blanket immunity for police or prosecutors in South Africa. They said such immunity is fundamentally inconsistent with the constitutional values of accountability, responsiveness, and the right to an effective remedy.
So no special protection just because they're state officials?
No. The court said liability shouldn't be blocked by some broad immunity. Instead, any limits on liability have to come from the standard legal principles we use in delict law. Was the harm foreseeable? Was there sufficient proximity between the official's conduct and the harm? Was it fair, just, and reasonable to impose a duty? Proportionality comes into play, too. It's about applying normal legal tests, not granting a free pass.
Okay, so immunity is off the table. The Constitution demands development of the common law to include positive duties. How did the court then apply this back to the specific officials, Klein, Lew, Olivier?
Right, they brought it back to the facts. They considered the police's constitutional and statutory duties preventing crime, investigating crime, maintaining order, and they weighed this against the known severe threat of sexual violence against women. Did Klein, Lew, and Olivier potentially breach a legal duty owed to Mrs. Carmichele?
Let's take Klein first, the investigating officer who recommended release.
The court looked at his positive recommendation for release. He knew about the prior conviction. Even if the community mislabeled it as rape, he knew it was serious. He knew the extreme violence of the ET attack. Releasing Coetzee meant sending him back to that isolated community. The court suggested that actively recommending release in those circumstances could very well constitute a negligent breach of duty.
And the prosecutors, Lew and Olivier.
Their duty, the court emphasized, was to put all relevant information before the magistrate deciding on bail. Senior prosecutor Lew knew Coetzee's history, his disturbing admissions about losing control, the community's explicit fears. Prosecutor Olivier knew all this, plus the outcome of the Valkenburg observation, when he failed for the second time to oppose bail or ask for custody.
So their failure to fully inform the court and argue for detention was key.
Potentially, yes. The court suggested that a negligent failure by prosecutors to present crucial information relevant to the risk posed by an accused could lead to state liability if that failure results in harm.
But what about causation? The state argued Coetzee might have been released anyway, given the legal culture back then focused on freedom. Did the court buy that?
The lower courts had leaned that way, suggesting causation was too speculative. But the Constitutional Court disagreed. They said, look, we don't need absolute certainty at this stage. We just need enough evidence to suggest that if bail had been properly opposed, with all the relevant, disturbing information put before the magistrate,
then bail might have been refused.
Exactly. That possibility that bail might have been refused was enough, in the court's view, to defeat the absolution application. It was enough to say, there's a case to answer here. The state needs to present its defense. It established a sufficient potential link between the official's failures and the harm suffered by Mrs. Carmichele to let the case proceed.
So the Constitutional Court sets all this out. A potential duty, potential breach, potential causation. What was the final order? Did they find the state liable then and there?
Yeah.
No, and this is a really important part of the judgment's nuance. The court faced a choice. Should it, as the highest court, now definitively develop the common law rule itself and perhaps even decide on liability?
What did they decide?
They decided not to. They felt it would be improper for them to act like a court of first instance on such a complex factual and legal issue, especially one involving the development of common law. They stressed the grave disadvantage of making such a final determination without having had the benefit of a full trial where all evidence could be tested and without reasoned judgments from the High Court and SCA specifically applying Section 39(2) to the fully explored facts.
So they laid out the principles, but didn't make the final call in this specific case.
Precisely. They recognized that absolution from instance is meant to stop meritless cases early. But here, where the law was uncertain and needed constitutional development, and where the facts strongly suggested a potential claim, justice demanded the opposite. Justice demanded refusing absolution and letting the trial proceed.
Why was that better for justice?
Because it allows for a full picture. All the evidence comes out, witnesses are cross-examined, and the trial court can make findings based on a complete record. Then, if necessary, appeals courts can rule on the law with the benefit of those detailed factual findings. It leads to better, more informed decisions, especially in groundbreaking cases like this.
So what was the concrete outcome? Where did the case go?
The Constitutional Court granted Mrs. Carmichele leave to appeal, upheld her appeal, overturned the absolution orders from the SCA and High Court, and sent the case back down to the High Court.
Back to square one, in a way.
Not square one, because the legal landscape had been fundamentally altered by the Constitutional Court's judgment. It went back to the High Court for the trial to finally proceed, but now under the clear constitutional directive that the common law must be assessed and potentially developed in line with the Bill of Rights, considering positive state duties, the state would now have to actually defend the actions of its officials.
Okay, let's connect this to the bigger picture.
Yeah.
What's the lasting legacy of Carmichele? It sounds huge.
It is monumental. Even though the Constitutional Court didn't find liability itself, it changed everything. It firmly established that the South African Bill of Rights isn't just a negative shield state, don't hurt me, but can impose positive obligations on the state to act, to protect citizens from harm, especially vulnerable citizens from private violence.
So it confirmed the state can sometimes be sued for not doing enough.
Yes, where there's a legal duty to act derived from the Constitution or statute, and that duty is breached negligently, causing harm. It sent a powerful message that state officials, police, prosecutors are not immune. They can be held accountable for wrongful omissions, for failing to act when the Constitution demands protection.
Especially in cases of gender-based violence.
Absolutely. The judgment specifically opened the door wider for victims of violent crime, particularly women facing gender-based violence, to hold the state accountable if official negligence contributes to the harm they suffer. And more broadly, it reinforced the duty of all South African courts to constantly ensure the common law evolves and stays in step with the Constitution's values. Justice isn't static.
So what does this all mean for you, listening to this? This deep dive into Carmichele, I think, really shows how one person's horrific experience and their fight for justice can ripple outwards, forcing a fundamental rethinking of the law.
It highlights that our rights aren't just words on paper. They demand active protection, sometimes requiring the state to step in, not just step back.
Right. It makes us think about what we expect from public officials, doesn't it? It challenges that old idea that the state's only job is to not interfere. Carmichele says, sometimes the state's job is precisely to interfere, to protect. It really forces us to weigh that responsibility.
It does.
So here's a final thought to leave you with. How does a case like Carmichele change the conversation in any society grappling with balancing freedom and safety? When does the state's failure to prevent harm become not just a tragedy, but a legal wrong for which it must answer? Something to think about.